The Civil Rights Act of 1866 was created to abolish discrimination because of race. Today it's in full force and effect. And let me make a comment about the Jones versus Mayer case. That was a United States Supreme Court ruling that upheld this particular Civil Rights Act. It wasn't that somebody challenged it. They wanted to make sure that the language was proper and was not out of date with current law. In 1968, we had another Civil Rights Act that included the Fair Housing Act contained in it. The Fair Housing Act extended discrimination to not only include race but also color, religion, sex, and national origin. It's important to note that the Fair Housing Act only applies to professionals in the housing industry, which means that anytime that a licensee becomes involved, that the Fair Housing Act of 1968 takes effect. And there are some exceptions to that. For instance, if an individual owns up to 3 rental units, it doesn't apply. But once they hit past that 3 rental unit and they own 4 and they don't live in any of them, then they become a professional in the business. In addition to the 1968 Fair Housing Act, in 1988 was an amendment that added 2 other categories. One, familial status, which are families that have children under the age of 18, and also handicap. Now, there was an exception to the familial status, and that was for senior citizens retirement communities. Those are exempt. Some of the activities that we need to be very careful about when we're practicing real estate, one is steering. Steering is where we're directing a person to or from an area for discriminatory reasons. Another is blockbusting. Blockbusting is inducing a person to sell because of something that's discriminatory. The last thing is redlining. Redlining was a banking practice where banks would block off areas and say, we're not going to make loans in these areas because of discrimination. Those are all things that are illegal currently. In addition, in 1988, the Americans with Disabilities Act came about, which has to do with public facilities, public accommodations, and commercial facilities for those individuals that are handicapped. Regarding the state laws that we deal with, probably the biggest state law that you need to be aware of is going to be the Florida Residential Landlord and Tenant Act. This was a law that was created to make sure that there was some balance between the landlord and the tenant, that one could not take advantage of the other. I think the big issue here, though, is where do we put deposits? So let me just kind of briefly go through the deposit issue with you, and I'm talking about security deposits. First of all, let's understand that a landlord is not necessarily a broker. In fact, in most cases, the landlord is simply the owner. And as long as that landlord, even if the landlord was a real estate agent, as long as they're not playing the role as an agent, then these rules apply. Keep in mind that when we're talking about a broker, brokers have to put money in escrow in a certain manner that we've already talked about. So as far as a landlord is concerned, a landlord can put security deposits either in an interest-bearing account or in a non-interest-bearing account that's separate apart from all other accounts. If they put it in an interest-bearing account, the landlord is going to owe their tenant either 5% interest or 75% of whatever they actually collected, and that's a landlord choice. Landlords can also commingle funds in their personal account. Now, this is something that a broker absolutely cannot do. If a landlord chooses to commingle funds in their personal account, here's the rule. First, they have to place a surety bond with the clerk of courts in the county in which the property is located in the amount of the deposit. And that's in case the lease terminates and the money's spent. We want to make sure that the tenant gets their money back. The amount of surety deposit or a surety bond cannot exceed or should not exceed $50,000. Secondly, they're going to owe their tenant 5% interest for the use of that money. So bottom line is that a lot of people don't realize that you're going to owe interest to your tenant if you commingle, and you've got to place a surety bond with the clerk of courts in the amount of that deposit. Now, if the landlord collects the deposit, they've got to notify their tenant within 30 days of where that deposit is being kept. Typically, it's spelled out in the leases. But if not, if it's on a separate document, they've got 30 days to do that. The other important issue that we need to be aware of regarding state law is going to be the Florida Uniform Land Sale Practice Act. This is where you have a developer or a subdivider that comes in and develops a subdivision that's dealing with 50 or more lots and selling to individuals, not other builders or other developers, but individuals. There is a public offering statement that has to be delivered, and that purchaser of that property has 7 days to rescind. In other words, they've got 7 days to change their mind about whether or not they want to continue with the contract or not. That takes care of our state and federal real estate laws. It was fairly to the point. To begin with, the 1866 Civil Rights Act simply has to do with discriminating because of race, and that was prohibited. The 1968 Fair Housing Act prohibits discrimination based on race, color, religion, sex, national origin, familial status, and handicap status in a residential transaction. Jones v. Mayer confirmed the validity of the 1866 Civil Rights Law. Steering is directing a person to or from an area because of discrimination. Blockbusting is inducing a person to sell because of discrimination. The landlord-tenant laws allow landlords to commingle deposits in personal accounts, but if they do that, they're going to first owe their tenant 5% interest for the use of their money. Secondly, they've got to place a surety bond, which is an insurance, in the amount of the deposit with a clerk of courts. The Florida Uniform Land Sale Practice Act requires subdividers selling 50 lots or more to provide buyers with a public offering statement giving them a 7-day period to rescind. And this is the end of this chapter's review.